Great. Should have started. All right, so as I told you, torts. We go longer in law school. Here for us going to be kind of brief. I hope we can answer all the questions and doubts you may have, but eventually specific situations I may not know the answer to you, because this is where things get a bit more interesting, because you see real life situations happening. So torts, what is torts actually? Torts is when we suffer damages or an injury. Under tort law, we have a remedy. Under tort law, we can sue the person or the entity or the party who caused this loss. Then we can seek for a remedy. So that's what we're going to talk today, or start talking today, the law of torts. And we'll be talking about torts and other types of liability too on Wednesday. So a definition for tort will be this social or civil wrong. So it's a wrong. It's when someone acts wrongfully. Okay, and social or civil. So that's a social or civil wrong, and then gives rise to the right to sue. So who can sue? The victim, whoever suffered the harm, whoever suffered the injury, the loss, right? And when they sue, when the victim sues, they will seek one of the several remedies in court. Usually it will be money. Usually it will be monetary compensation, as we saw last week. But it may be that I am acting wrongfully towards you constantly. So on the top of damages, you want me to stop acting wrongfully. So you could seek an order. In court, we would call this stop order, an injunction. So João, the judge, would issue an order that I would stop acting wrongfully. Okay, so that's an example. But in most cases, the victim will seek damages. Okay, and we saw last week, if you were paying attention online, not multitasking, we saw general damages, special damages, punitive damages, the main damages. There will be a short review in a minute. So a tort can be intentional or unintentional. The most common type of tort will be the unintentional one, because in most situations, people will cause loss to others unintentionally because they were careless, not because they intended, not because they wanted. Okay, but yes, there are intentional torts. This afternoon, we'll be focusing on the intentional torts. And then on Wednesday, we'll be talking about the unintentional ones. Okay, the careless ones. So the main focus, main objective of tort law is to compensate the victims. So that's the main objective. Now, because it compensates, it allows for victims to be compensated. It also acts as a deterrent, as educational to society. Well, if you know that if you act wrongfully, you may have to pay compensation, well, it may educate you, or it should educate society. Okay, but that's a secondary objective. The main objective is to allow victims to sue mainly for damages, for money, compensation. Are we good so far? Yeah. All right. Now, tort is not a criminal offense. Remember, we will not be discussing criminal offenses in this course, but I have to differentiate what a tort is from a criminal offense. A criminal offense, first of all, has to be prescribed in a criminal law, in the criminal code. There's no crime, there's no criminal offense if that criminal offense doesn't exist yet in the law. In other words, I cannot be prosecuted for a criminal offense that doesn't exist yet. Okay? But with regards to tort law, Courts, they may recognize new torts, torts that haven't been recognized yet. So that's the first difference. Torts, there may be new torts coming now and then. Criminal offense, only if it's prescribed in the law, only if government has passed legislation, politicians has passed legislation. Now, a criminal offense is also a social wrong. However, a criminal offense is a social wrong that affects society as a whole. When there's a murder, when there's a robbery, theft, those criminal offenses, they affect society as a whole. And because they affect society as a whole, the government will prosecute, the government will go after. Remember, we discussed this last Wednesday. When there's a criminal proceeding, it is the government that goes after the accused, not the victim. Okay, so the government, so state here, government, and the focus with criminal offense is to punish the wrongdoer. Tort law is not about punishing, it's about compensating victims. You get the difference? Now, I told you last week that one conduct may be both a criminal offense and a tort. So let's say, come here now. If I steal your smartphone, is this a criminal offense? It's a criminal offense. Can you come after me in a criminal offense?
Yes.
No, the government will come after me. You will report to the police. But you may be injured, you may be, so you should not do that, I would say. But, okay, so criminally, you don't come after me. But did you suffer a loss when I stole your smartphone? You did. Can you sue me for compensation? Yes, you can. So you will sue me under tort. The government will come after me under the criminal offense. So it was only one wrongful conduct. My wrongful conduct was to steal your smartphone. But I could suffer two different proceedings. One from the government, criminal offense. I could end up in jail, probation, any other consequences. Tort, you would sue me to be compensated for the loss you suffered. Is this clear?
Yeah.
Any questions? All right. Now, remember last week we talked about the burden of proof. We talked about the burden of proof in civil matters, and we talked about the burden of proof in criminal matters. In civil matters, balance of probabilities. So when you sue me, you have to prove I caused you losses, damages, on a balance of probabilities. Now, when the prosecutor comes after me criminally, they have to prove the case. What is the burden of proof in criminal law? Okay, that's a concept, but there's the specific
Beyond a reasonable doubt.
beyond reasonable doubt. So the specific burden of proof. And this is a valid concept. So everyone is innocent until it's proven contrary. Very few exceptions. But this means that the prosecutor has to prove I stole the smartphone beyond a reasonable doubt. So the job of the prosecutor is more difficult than yours when you sue me for the same conduct. This has to be clear to you. This is very different thing, a very important difference. Okay? All right. Now, tort is the civil wrong. Main objective, compensation. Criminal offense, also civil wrong, but affecting society as a whole. Main consequence, the criminal law consequences like jail, probation, etc. The government prosecutes. Now, we can also suffer losses if the contract is breached. If I buy coffee, it's a contract. If they give me tea, they have breached the contract, right? When this happens, you can sue the coffee shop. You would not, you wouldn't sue for $3. You could, Now, a breach of contract may also bring or cause losses to one of the parties. But that loss is not related to a tort necessarily. Okay? A breach of contract is not a wrongful conduct necessarily. It may be that I ordered coffee with milk, 2% milk. They gave me coffee with 0% milk. It's still a breach, but I still got the coffee and milk. Right? So it's not a wrongful conduct, but it's a breach of contract. So breach of contract is not a tort. How do I know I will sue under tort? I will sue under contract. Well, when can you sue under contract? What do you think? You can guess. It's quite logical, but
Didn't make damage, big damage.
didn't harm, big damage. Not the key aspect.
What about like in a situation where you sign a contract with your landlord and they evict you because they want to sell the property?
Okay, could be, but let's not overthink. Let's just think about this. When is it a breach of contract? What is something that is needed for a contract to be breached?
When it's violated,
Signature.
When the contract
it's violated.
is violated. Signature. Well, actually, to make it very simple, but in those lines, there has to be a contractual relationship. If you are not in a contract, you cannot be a victim of breach of contract. Does it make sense? Does tort require a contract? No. A tort is when we suffer damages, losses, intentionally or unintentionally, regardless if we had any relationship with the wrongdoer. Now, a contract can only be breached if there's a contract. Are you in contract with BCAT?
Yes.
Yes, you are. You have an educational service agreement or contract. So can BCAT breach their contract with you?
Yes.
Yes. Yes, they can. Can you breach the contract with BCAT? Yes. Yes, you can. Now, can BCAT commit a tort? Can you commit a tort against BCAT? Yes, you can. Torts, they do not require contract. But a breach of contract does require a contract. Right? So you will never sue under breach of contract if you are not in a contract. But you may be able to sue under tort if you suffer damages. Does it make sense?
Yeah.
That's very important too. Okay? Yes, sometimes the wrongful conduct that leads to breach of contract may also be a tort. Could be. But then this will be decided on a case by case basis. Okay, so it could be that we are in a contract and then I committed fraud, I committed some wrongful conduct that also led to breach of contract. Could be. Okay, but a contract is required. Now, this is just a review. So damages, you know, they are monetary compensation. You know that special damages are the actual costs you suffer, the actual loss you suffer. General, they are related to future losses, pain and suffering. Those are general damages. You can seek them. And then punitive damages when there's usually bad faith. If there's bad faith conduct from the wrongdoer, there may be punitive damages. Now, it's just a review from last week. Now, what we're gonna go through this afternoon will be some torts that impact businesses. And we're gonna go through assault, battery, negligence on Wednesday, trespass, those liabilities and negligence will be next week. But we're gonna look at this vicarious liability concept now. What is this? Vicarious liability is when there's liability, when a party is liable, even though they were not at fault. A party is liable even though they were not at fault. I was not at fault, but I'm still liable.
'Cause
You are not at fault, you're still liable. Why? This is to protect the victims. What is the best example for vicarious liability? Employment relationship. Employers, they are vicariously liable for the wrongful conduct of their employees in the course of employment. So if I am mad at you, I get a laptop and I throw on the floor. During the class, you can sue me. I was wrongful. I acted wrongfully, but you can also sue BCAT because BCAT is vicariously liable. Okay? Now, you may agree that BCAT is slightly richer than I am. Why is this a benefit for you as a plaintiff?
Claim for money.
Compensation is great.
Yeah, to get the money, because it may be, remember last week, it may be that you win the lawsuit against me, but I cannot afford to pay the loss to you. Whereas BCAT being slightly richer than I am, they would be able to pay easier. Does it make sense? Yes.
But then to make sure that wouldn't happen, would you like get a restraining order on that student? Because they damaged your laptop, so you can't really do anything towards them, so would you get a restraining order if they threw your laptop on the ground?
What? No, it's throwing the laptop. So it's, I caused him damage
Yeah, but you did it purposefully.
or accidentally.
Oh, wow.
It doesn't matter. Because it's in the course of work, because I'm delivering the lecture. You could sue me and BCAT together. Why would the restraining order be used?
Well, so like when BCIT pay the money for the laptop, so why would you sue them as well as giving from BCIT? So would you be compensated from BCIT for the laptop? So instead of suing, could you just put a restraining order on it? Just
The restraining order wouldn't bring you the compensation for the loss you suffered.
it
I
would-
just don't understand that. I just don't understand why use a restraining order as a remedy. Restraining order is an order for someone to stop doing something,
Yeah,
but I have already caused him damages.
what if he does it again?
Okay, but then if I do a second time or third time, then you have grounds for a restraining order.
Well,
Yeah, but if I cause damages, you wouldn't think of a restraining order. You think about being compensated for those damages you suffered, right? So you have a conductus.
Yeah, I was gonna say, who determines the compensation? Like, does the victim set the amount and then the court has to agree?
Okay, here, you, the victim, the plaintiff, they seek special damages. The losses they suffered. Maybe because I caused physical damages or damages to the laptop, but I was so mad that the student may also have suffered some pain and suffering, some anxiety, mental anguish. General damages could be there as well. So damages in law, they are recovered as long as you can prove them. It's not just a rough estimate or something you want or you wish. No, it's something you actually suffered. Does it make sense?
Yes, but like, let's say a headache, how can you determine how much a headache is worth?
Oh, that is based on, well, you will seek general damages, you will prove you actually suffered that headache. Then, yes, the court will estimate based on case law, based on past decisions. But you have to prove it. Okay, you cannot only seek damages because you want them. No, you suffered $1,000 damages, so that's what you're gonna seek. On the top of that, lost wages for 10 days. So that amounts to, let's say, $2,000. Also get damages in that amount. Okay, so you have to prove that. So that's vicarious liability. So as I said, the party without fault, they are also liable. So employer. Now, you as an employee, if you work, you are attracting liability for your employer. Your employer may have to pay compensation because of what you do. Now, if BCAT, in this example, if BCAT pays out compensation to you, can they come after me? Because I was the one actually wrongful. They were not. Can they come after me? Yes, they can. They usually don't. Employers usually don't. They usually rely on their liability insurance. But what they should do is at least they should discipline me because I acted wrongfully. And then if I continue on acting wrongfully, they may be able to dismiss me for just cause because they have progressively disciplined me. Okay, so that's usually what happens. But they would have a right to. Yes.
This question might be more along the lines of employment law, but does that mean that the company has has to give you the right to discipline you rather than dismiss you when such a situation arises?
Well, companies, they can dismiss you as long as the employee acted wrongfully in a very serious manner. When we talk about employment law in chapter 12, we'll see that courts, they require this progressive disciplining before just cause dismissal, unless the wrongful conduct was really, really serious, such as a criminal offense. Okay, but we'll talk about that in details there. Another example for vicarious liability will be when the owner of a car. So this is related to the law statute. So if I own a car, who owns a car here? Okay, you do. So if a friend borrows your car and they cause losses to others, the victims, they can sue your friend and you too, because you are vicariously liable. If you end up paying compensation, can you go after your friend? Yes, you can, because they were wrongful. Okay, yes.
So allowing the person to drive your car, so you're giving them permission.
Okay,
So how can
that
I,
is fine.
yeah, so how can I go after my friend when I'm allowing them to go using the car and to do something with them?
Because they have caused you damages. They drove your car, they caused damages to a third party. Third party sued them and you. They don't have money, you have to pay. So you allow them to drive your car, but not necessarily to cause you damages. Oh, that is an insurance aspect of it. I'm just saying that, yes, there's ICBC insurance, it's mandatory, you make a claim to insurance. But what if ICBC does not cover the whole amount? Because they assess the damage as, let's say, 100,000, but the victim actually wants 200,000. So they may sue you and your amount. Okay, if you end up paying, you can go after your friend. There's another example, which is children when they cause losses to school premises. The School Act says that parents are vicariously liable for the children's losses to school premises. My daughter is at school. If she causes damages to the school premises, I am vicariously liable. That's her father. I was not at fault. My daughter was. But I am vicariously liable. Now, I've given you several examples. Car, employment situations, parents. Now, just to emphasize that vicarious liability exists to protect the victims, because the victims have better conditions, better options to seek for compensation. Okay, because they have two avenues to go through. And keep in mind that it's not because the victim can sue BCAT, they cannot sue me. Yes, they can sue me. I was the one who acted wrongfully. So the victim can sue both parties. They will not recover twice their damages, no, just once. But at least they will try from each of the parties. Okay? That's vicarious liability. So let's start with intentional torts. Well, first thing to mention to you is that an intentional tort means that the conduct was intended, was deliberate, was willful. So I acted that way because I wanted. There was intention to act that way, regardless of the damage. So in an intentional tort, the damage, the harm is only relevant for the damages, not for the conduct itself. Now, I'll use you as an example. If I come close to you and I threaten to punch you, or just an example. This is, you were a victim of an assault. I assaulted you. Now, in principle, I haven't caused you any damages, or even if I did, that is irrelevant for the assault. The intensity of the damage I may have caused you is relevant for your compensation in court, but not for the conduct. So even though you were a victim of an assault, and eventually I will claim in court that you didn't suffer any damages, anything, I was still a wrongdoer. You were still a victim. Because what matters is the intention in the conduct, not in causing harm. Okay? The harm, yes, the harm will be used for compensation. The more the harm, the more the compensation will be. So that's intentional tort. Again, there's no need to intend to do harm. Okay, but if there's harm, compensation may be higher. Now, this will be important when we talk about negligence. When we talk about negligence on Wednesday, I'll tell you that a harm, a loss, an injury is required. This is not the case here. Okay. So let's start with assault and battery. So assault and battery. Well, I just gave you an example of what an assault. What is this? You fear that you are about to be struck. You are not struck. I don't punch you. I don't touch you. But you just fear because I came to you and I was like this. Or even if not like this, but if I'm yelling at you and pointing my fingers at you, eventually you believe you may be hit. That's an assault. But there's no physical contact. No physical contact, no punching, no pushing, no. If there is physical contact, a punch, a push, it is battery. It is battery. Now, assault, no physical contact. Battery, physical contact. Now, there's a criminal offense called assault. This assault is not a criminal offense. This assault is tort. Tort law. I'm not talking about criminal offense. Okay? So if you are about to be struck, or even if I have my clicker here and I threaten to throw at you, I just threaten to throw. If you fear to be struck, you were a victim of an assault. Now, if I throw this at you and you do this and it doesn't hit you, you are still a victim of an assault. No battery. If it does hit you, then you are a victim of battery because of the physical contact. Okay? Now, how can you defend yourself if you're being sued for any of this? First defense will be consent. If you gave consent. So let's say, let's play soccer and you agree to play soccer. Playing soccer, there's physical contact. So if I hit you because we are playing soccer and you sue me, I say, no, but you consented to play soccer. I didn't threaten you. Or doctors, what do doctors do? They get a consent, usually in writing. If they have taken B-law classes, they know they should take in writing because it's better for their evidence. So they say there will be a procedure in my arm, so they get a consent from me that they can touch my arm. Can they go beyond consent? Only if it's an emergency. If it's not, they cannot. If they go beyond consent, is it battery or assault? Battery, because the physical contact. Okay? So consent is one defense. Another defense is self-defense. But self-defense has to be only the necessary force, a reasonable force. Whether the reasonable force was used in a specific situation or not, this will be a question of law that the judge will decide on a case-by-case basis. But I can give you an example. Let's say a child trespasses to my backyard. Child is in my backyard without my authorization. So I get my gun and I shoot the child. Is this necessary force?
No.
Not at all. Not at all. So we cannot abuse the force. Even if, let's say, we go to a bar. I'm gonna use myself. I go to a bar, I drink too much, and the server stops serving me because I'm drunk. And they say, hey, João, you should leave. I don't know you, but me, when I was younger and when I drank too much, I used to be the strongest person in the room. No one could come close to me that I would punch them. Well, just thought I was strong. But then if the security guard comes and remove me from the bar, take me out with the necessary force, this is not battery, this is self-defense. But if they push me down the stairs, this is more than necessary force. This could be battery on their side. Okay? But I'm not trying to give you the very close fixed answer to all circumstances. I'm just giving you some examples. Okay? Again, the judge will decide on a case-by-case basis whether the force you used was the necessary, reasonable one or not. Are we good? All right. Now we have trespass to land. What is trespass to land? Is when we are at someone else's land without their authorization, or because we do not have the legal authorization. Like if we work for Amazon delivering their goods, DHL, FedEx, Canada Post, we are legally allowed to enter the property, at least to drop the goods, the packages. But if we are not, we need to get that consent of the owner. If we don't get the owner's consent, authorization, we are trespassing. Now, yes.
What about, oh, you're trying to say it, what about for the people who come to your door and knock and try to sell you stuff?
Solicitors.
Yeah, the solicitor.
Door-to-door salespeople.
Yeah.
In principle, they can. They can come to sell, unless you have a sign. You may have a sign, yes. No soliciting. Then they shouldn't come. But they are not there in your property with the intention to be in your property. But they are there with the intention to sell you something. That's why it's different. Okay? Now, the only defense available here is if you end up at someone else's property accidentally, not by mistake. If I come to this property here, oh, I didn't know this one belonged to you. Oh, sorry, I made a mistake. I didn't know this belonged to you. This is not a valid defense. If I don't know who this belongs to, I should ask. I should inquire before I enter this property. Okay? You see in construction sites, no trespassing signs. You see a lot of signs, no trespassing. That sign is not required. Why is it there? Well, it's there just to make sure you don't enter that property. But it's not required by law. Okay, we should inquire if we are in doubt, whether we can be there or not. Okay, yes.
Why is construction sites not required? Because that's a hazardous area, so people should not be entering.
No, the sign
sign.
is not required anywhere.
Not even construct, why not was construction?
Anywhere, because I have to ask if I can be there or not. So there's a fence. Usually on a construction site, there's a fence. I should know that I cannot be there unless I get authorization to be there. So when I say the sign is not required, I mean that if there's no sign in a construction site, then I enter, then they sue me for trespass, and then I say, oh, judge, no, so there was no sign. The judge will say, regardless of the sign is not a legal requirement for us to protect our property. Okay? But they use just to make sure you don't trespass. So not only being on someone else's property, it could be that we throw objects. If we throw garbage, if we throw a box, this could also be trespass. Right? During the fall, when the leaves are dry, if you put them in your neighbor's property, it's trespass, it may be trespass. Yeah. Now, if you have a tree and the tree branch is going over the neighbor's property, could be trespass tree.
Is that why the city cuts it all? Up?
Oh, the city cuts, the city has no obligation for me. If my tree branch is over someone else's, my neighbor's property, it's my obligation to trim it.
Oh,
And if I don't, it's not a city, yes. Okay? Is it okay? Is it going okay so far? All right, so that's trespass to land. Oh, one other thing here. When we go to, do you know Metropolis Metrotown?
Yeah.
It goes by. When we enter Metropolis Metrotown, we don't need to ask authorization to enter there because it's a public mall. It's a mall. But if you don't behave well, they may come to you and they may revoke your license. They may say, hey, you're not behaving well. Please leave. They cannot say leave because of human rights protected grounds, because of your ethnic origin, because of your religion, gender. No, these are not valid reasons. But they may come and say, hey, you're not behaving well. You're running, you're playing, or throwing objects at some other people. So they may ask you to leave. When they ask you to leave and you say, no, I will not leave, then you are trespassing because they had revoked your license. Then they can remove you physically from your place. Okay. Now, trespass to chattels, conversion, and that news. So 3 different torts related to goods. Chattels means goods. Chattels means goods. Why do we use chattels and not goods? Chattels, we use chattels because it's legal terminology, and then lawyers can charge clients higher, right? Because they know the terminology. I'm joking. Well, it's terminology. I can't tell you why. Yeah, but we have to know. So there's a tort that is called trespass to chattel. Trespass to chattels means that possession is interfered physically. So it's when I hit your laptop screen and I cause you damages. Or if I take your laptop and I say, no, you're not going to work. So I'm interfering with your goods. If I do this intentionally, you can sue me for trespass to chattels. Or it's not uncommon. We see on TV, a driver is waiting to park their car in a parking spot. Someone is just driving away, but a smarter one comes and parks there faster than you. So the driver that was waiting gets mad, leaves the car and knocks the other driver's car.
like drive into it?
Could be drive or could just knock, just punch the car. So this will be also trespass to chattel. It's when our goods are interfered with, when our goods are damaged by others. Now there's conversion. What is conversion? Conversion is intentionally appropriating the goods that belongs to someone. When I steal your smartphone, am I not appropriating intentionally? Am I not intentionally getting from you without your authorization? So the criminal offense of theft is the tort of conversion. The criminal offense of theft is the tort of conversion. Now you report to the police that you were a victim of a theft, but then you sue me in private civil courts for the tort of conversion. Okay? The act was the same, But the tort, you sue for compensation. The criminal offense for the criminal law consequences. That's conversion. Now, that new is wrongfully retaining the goods, not appropriating, but retaining the goods. So if you give me your smartphone, you give me so that I take a picture of you. Am I intentionally appropriating from you?
No.
No, because you're giving it to me, right? Instead of taking a picture, I run away. I run away with your phone. That's that new.
That's what?
It's new.
That new.
It sounds French.
Yes, that new. So it is not conversion. Conversion is when we appropriate intention, and that new is when we retain. We refuse to return. You gave your smartphone to me for me to take a picture of you, but it could be that we go to a library and we borrow a book and we intentionally do not return. We intentionally decide to be with the book. I'll keep the books or the book with us. Are we good so far?
Yeah.
All right. False imprisonment. This is when people are restrained physically against their will. So if I come here and I say, hey, no one lives, everyone stays in place. If it's against your will, if I have no legal rights to do this, you are a victim of false imprisonment. When does this happen commonly?
In exams.
Why? Why would an instructor hold students in an exam?
Cheating.
Hmm?
Cheating.
No, cheating, you just stop the exam right away and you send them out. But where does false imprisonment happen more constantly?
Places.
What places? Where?
Work,
Court
work.
or work?
Stay there for 8 hours.
No, but you're working, right? You're exchanging your time, labor, experience for money benefits.
So I think Rihanna said, relationships.
Yeah, relationships.
It should not. It should not. Okay, I'll try to help you.
Okay.
Let's say. Okay, if I come here and I believe you stole something, I need to search your bag. If I ask to search your bag, it means I'm telling you to stay here while I search your bag. And if I don't find anything,
When you have doubt about something,
sorry?
when you have doubt about something,
Yeah, and if I don't find something, if I don't find anything, you didn't steal anything. You were restrained from living. So you were a victim of false imprisonment. Where does this happen? Quite commonly, unfortunately. Mall, public places, usually department stores, grocery stores. Because of small, do we call it small robberies or small thefts?
Shoplifting.
Yeah, shoplifting. Yeah, with shoplifting is unfortunately common nowadays. So if a security guard thinks that someone stole something in the store and they come, hey, stop, I need to search you. They are restraining the physical liberty of the person because the person was just living, right? And then if they don't find anything, it's false imprisonment. If they find something, then they can arrest. Any of us can arrest someone who has just committed a criminal offense. Now, what is the burden of proof of a criminal offense? Beyond a reasonable doubt. So I'm not a prosecutor, I'm just an instructor, but I believe that you stole something from your classmate. If I am in doubt, I should not search. Because even though I'm not a prosecutor, to be sure you stole something, you committed a criminal offense, so that I can make use of the citizen's arrest, I would need to be sure you did it. So it's not easy. And security guards, they shouldn't be searching people freely. They should be sure someone committed a criminal offense. Okay, now, yes.
Was it, yeah, I'm gonna cover this next, but if like they do search you and they find nothing, can you sue them?
Can you help me answer this question? If I search someone and they don't find anything,
Yes.
Sure.
sue under what? Tort? What's tort?
Or
This
is
tort.
it-
That's what I'm explaining now. It's the false imprisonment.
So you can, this is when you can sue them under false imprisonment?
Yes,
Oh.
if I am searched and nothing is found with me, I was a victim of false imprisonment.
So they don't have like legal defenses against that, like, hey, the alarm beeped, so true.
Well, the alarm beeped. Well, that's high suspicion. That could help in a defense. But even before searching, they could ask, or they could do some other things. But yeah, then you get to some details that eventually they could get away from the malicious prosecution. And mainly nowadays with alarms and electronic, sometimes the alarm may be, but it's because the cashier forgot to remove the physical device, right? Then if I would establish in court that I paid, I had a receipt, I showed the receipt, and even though I had showed the receipt, the security guard would still want to search me, then it's more likely a false imprisonment. Okay, so again, depending on what is happening there. And now the only valid defense is the citizen's arrest. But we can only arrest if we are sure someone committed a criminal offense. We can arrest and we should call the police right away. We cannot arrest and keep the person with us for long. If we do that, could be kidnapping, could be a criminal offense. Okay, so we cannot abuse on this. All right. Malicious prosecution. This is not so common nowadays, but this is when someone or a party, a company could be, uses the criminal system, the criminal court system to do bad to someone. So I don't like my neighbor. I don't like my neighbor. So I call the police and I say, hey, there's a resident at this address for my neighbor's unit. They are a drug dealer. They are not, but I'm just calling the police because I don't like them and I want to do bad to them. And out of malice, if they are investigated, nothing is found, and they learn I did it, they can sue me under malicious prosecution. Right? Because they use the criminal system to do bad to them. Again, I would call the police. Police would start the investigation, or they would ask for some proof I wouldn't have. So policemen, they are not that unsmart or unwise, right? So they know what they do. So that's why this is not so common. But it could be, for example, let's say BCAT fires me, and they fire me, and they also report to the police that I committed some criminal offense. My manager was mad at me. So in this situation, they would investigate, and if I was not found guilty, I could then come after BCAT. So that would be more common in former employment relationship. I think that's one of the examples you have in your textbook. But again, I've never seen any malicious prosecution lawsuits. Yes.
The first incident that you were talking about, like with the police, how you called about the neighbor.
Mhm.
So if they found out, they would sue you under the
Malicious prosecution.
executions. Well, wouldn't you also suffer from a fine from calling like emergency services without proper intention?
Could be, but that would be a civil violation. This would be related to a bylaw. And even that fine doesn't go to the neighbor.
Or go to
It's because I
you?
did wrong, yes. So the neighbor could still sue me.
You would have to do 2 lawsuits.
I could eventually be issued a fine, I could be prosecuted, and I could still be sued for malicious prosecution. Now, everything I'm explaining here to you under tort does not mean you would not, as a wrongdoer, you would not suffer the consequences of other areas of law. There could be other areas of law that would impact
Yeah.
the wrongdoer. Okay? All right, so that's malicious prosecution. Let's break for 10 minutes. So please be back here. 2:35, 2:37. Remember, if you were late, come talk to me for attendance, please. I'm not to stop it.
That's more of a basic of those.
Yeah.